therefore, we advise counsel for the respondents that when the time comes for their turn to make submissions, they won't be interrupted. Nobody will interrupt them, but they should point out whatever objections to the evidence they would have noted during the petition submissions. And the court will give due attention to all submissions and the points of law raised. Thank you. Mr. Oraro.
My Lord, I must start by saying that it is my honor and privilege to have this opportunity to address the first presidential elections before election petition before your lordships. My Lord, at elementary level, this petition is about the validity of the presidential elections held in Kenya on March 4th, 2013, and consequential results which were declared on the 9th. But we have to remember, my Lord, that there are that class of Kenyans who, when the new constitution came in, some of them cried. And it gave them a new dawn of hope that Kenya had changed and changed forever, never to go back to where we were before. And therefore, for this class of Kenyans, this petition has greater significance than the mere contest between the two antagonists involved in the petition. For them, it is about whether Kenya and its institutions has come of age to deal dispassionately, courageously, without fear or favor, and in full faithfulness to the attendance of oaths of office which your lordships took with a matter of this magnitude. My lords, my lady, it is about restating and safeguarding jealously the irreducible minimum standard for our electoral system. It is about nurturing and enduring democracy for Kenya. My Lord, Kenyans out there are today divided in equal numbers on opposite sides, looking at each other, but waiting to see what your lordships will do in terms of resolving this difference which has been brought before you. It is about recapturing the confidence of the people of Kenya in their institutions of governance. My Lord, most importantly, it is about a robust audit of the institutions that are vested with grand governance obligations in Kenya. My Lord, that is what this constitution is about. And therefore, we better see it on wider perspective than the parties directly involved. My Lord, I have filed my written submissions together with authority, and 8 copies were retained in the registry, and I hope that your lordships will get your copies in good time. Let me give you a brief factual background to my submissions. My Lord, this petition arises out of presidential elections carried out on 4th March 2004, in which 12,221,053 valid votes were cast. And my Lord, 108,975 rejected votes were set aside. And this was against what was said to be a total number of registered voters of 14,352,533. The voter turnout, the largest in any democratic country. My Lord, this number of voter turnouts you only get in communist countries and it is because we know how they're achieved. Now, the third respondent was declared the winner of the said elections, having, according to the declaration, secured more than a half of all votes cast in the said elections as provided for under Article 138 4A. But my lord, Article 138 is a peculiar provision, and it brings to this court peculiar considerations in respect of which you cannot apply the general electoral provisions as we know them. Under Article 138, my lord, 4, a candidate shall be declared elected as president if the candidate receives more than a half of all the votes cast in the election. So that is the first thing. He must receive more than a half of all the votes cast in elections. And 2, at least 25% of the votes cast in each of more than a half of the counties. So that, my lord, in making your consideration, my lady, what you will be considering is not the large difference between the candidates. What you will be considering is what the winning candidate has achieved above the 50%. And that is the matter you have to keep central in your consideration. And my lord, it is unlike an election which would be run if they go back for fresh elections, because in that respect, my lord, Article 138 7 says that in that election, the candidate who receives most votes in the fresh elections shall be declared elected as a president. And there are no conditions to that declaration, my lord. My lord, copies of the first respondent's minutes, dated 19th March 2013, attached to the affidavit of Ahmed Isaac, the chairman, and the second respondent, dated 19th March 2013, at the response they have filed in this court, and which is found in volume 1, page 35D, show that the third respondent has received 50% plus 8,419 votes, and accordingly was entitled to be declared elected as the president. So, my lord, what we are concerned with is when we go through all these irregularities, we shall have to put in the back of our mind that do they go on to the transparency? In fact, the factors to be considered, my lord, I think is Article 86. Let me just read them so that, my lord, what is expected of the second respondent is Article 86 states that whatever voting method is used, the system has to be simple, accurate. Accuracy is very important. Verifiable. So it must not only be accurate, but it must be verifiable, secure, accountable, and transparent. That is the constitutional threshold, reducible minimum upon which the first respondent is expected to operate. And therefore, what will tie up your minds as we go on is, looking at all the irregularities we will point out, does it make the elections not satisfy the constitutional threshold set up by Article 86A? That is on one side, my lord. On the other side, you will be dealing with a mathematical exercise that even if the elections were carried out reasonably properly, and it satisfied all the constitutional thresholds, if there is a difference which affects more than 8,419 votes, the elections had in any event to be set aside, and that is a constitutional threshold. It is not a matter of discretion for your lordships. My Lord, we will show that in evaluation of the evidentiary material presented to this court, including Form 34 and Form 36s and the final tally, as well as the principal register of voters, the first respondent did not carry out his constitutional mandate, and the third respondent did not meet the threshold set out in Article 138(4) of the Constitution to be declared the president-elect. My Lord, you will hear a lot of objections as to why are we looking at Form 34s, and why do we make any deduction from the Form 34s which have been produced before this court. But my Lord, what you have to have in the back of your mind, when a party produces evidence documentary evidence in court, what is it for? Is it a decoration? Is it supposed to be kept in archives and locked there, and then the parties can come and have an academic argument, my Lord? The purpose of filing evidence is so that it can be analyzed. And to the extent that the Electoral Commission has filed its Form 34s and 36s in this court, each and every party is entitled to analyze, scrutinize them, and submit on them before your lordships. My Lord, it need not be gainsaid that the client I represent, the petitioner, was dissatisfied with the results and has filed this petition under the provisions of Article 140, challenging the validity of those elections. My Lord, the full particulars of the challenge of the validity is found in the petition, and I will not necessarily go through each and every ground, but my role will be to try and assist my lady, your lordships, to fully understand the main issues which the petitioner is bringing before this court, and to help your lordships understand that they're not flippant, they are grave issues. They go to the very basis of elections in this country. They are important for future elections in this country, and it is important that we address them and stop looking at this issue as a matter between President-elect and my client Raila Amolo Odinga. It is more than that. It is the future of this country we should be dealing with. My Lord, let me now go to my first issue, which will detain most of my submission this afternoon. And that is, my Lord, the issue of voters' registration and the surrounding issues of voters' register and use of technology in elections. My Lord, the historical perspective of these elections has regrettably and very unfortunately to be considered in the context of the unfortunate events following the 2007 general elections. My Lord, during which time a number of Kenyans lost their lives, lost their property, and which led to violence in several places and loss of life amid flames of election fraud. We are all aware that this led to the African Panel of Eminent Persons brokered peace and initiated the urgent reforms, amongst which was the review of the Kenyan electoral system. My Lord, as you can recall, this was carried out under the purview of the Independent Review Commission on the General Elections held in Kenya on 27 December 2007, IREC, which was established, and its report, my Lord, is found in our petition from page 1 to page 173 of the annexures to the affidavit in support of the petition. My Lord, I was happy to see Mrs. Lucy Kambuni around because she was one of the members, and I thought she would be applying to be amicus curiae. Yeah. Now, my Lord, among the concerns IREC raised and which will be shown to be relevant to these proceedings was the process of tallying, which has come again now to be one of our major problems, and compiling results. And my Lord, which that commission established then, and we will show now, and unless it is addressed, it will be in future, that it is prone to making random errors resulting in significant gains or losses to certain candidates, and could therefore not meet basic international standards of transparent, free, and fair elections. My Lord, what we will be showing you as we go on is the process which has been done is very clever. Take a few votes from one candidate, 150, 200, reduce his numbers. Then increase a little the votes of another candidate. And by the end of the day, you have a situation where you end up in a process which achieves the result you want to achieve. That is what happened, and we will be able to show you that, my lords. And that is why there are these contradictions in Form 34, 36, and when you see one form, it is 50. But when you see 33,000 forms, then it is 50 times 33,000. And in a situation where we are talking of a difference of 8,000 votes. Now, my Lord, the following recommendations were made to ensure that these unfortunate events are not repeated. And my Lord, I will read them because it is important that we bear them in mind as we go to consider what is the position in the case we are dealing with. The recommendations are found at page 148 of the petition, volume 1, and they are that IREC recommended that ECK integrate the various descriptions of the entire counting and tallying procedure into one document only, which will then be the principal description and must be adhered to. The need of such descriptive regulation does not depend on possible changes on the counting and tallying system. So, first issue was immediately change the number of forms. As you remember, on the 2007 election, there were Form 16, Form 17, and manipulations of those forms. So, the intention of this recommendation was to have only one form. And my Lord, when you look at the regulations, that form was intended to be Form 34. What has now happened? They have now introduced Form 36 as the operative form, and I will show you, very contrary to the law. And it is between manipulation of the figures on Form 36, Form 37, and the final tally that the whole game is played. My Lord, the next recommendation was that IREC recommends that without delay, ECK start having developed an integrated and secure tallying and data transmission system, which will allow computerized data entry and tallying at constituencies, secure simultaneous transmission of individual polling station level data to the National Tallying Center, and the integration of this result handling system in progressive election result announcement. My Lord, that is what the first respondent pretended to be doing when all its systems collapsed. And that is what it sold to the public it was doing, and that is what the parliament reduced to the electoral system Kenya wanted to have. My Lord, all that is water under the bridge. We are back to manual tallying. We are back to 2007. Then, my Lord, the other recommendation was that IREC recommends that ample time be allowed for verifying provisional results so that they are declared final official only once there is no risk that errors may still be found or non-frivolous objections raised. Most countries allow 1 to 2 weeks for this. There must be sufficient time to check the provisional results, which are given status as final results only when all the objections have been considered, all checks and rechecks conducted, and the final verdict issued by the proper authorities. Given a clear explanation of what provisional result is, there is no problem in making voters understand that election results are so important that they can be declared final only once they have been properly scrutinized and checked. My Lord, you will find that at page 172 of the petition, and that is part of the direct report. So that, my Lord, what was anticipated was that in spite of all these electronic means, you would give all parties concerned an opportunity to interrogate whatever returns have been made, make all of the objections they have, and it is only after that is done that you would then announce the final result, and hence the provisions of the regulations allowing the IEBC to announce final results only after 6 days of verification, tallying, and finalization. My Lord, that is not what happened. I will show your Lordship that instead my client's agents were thrown out of the tallying. My Lord, numerous constitutional, legislative, and regulatory steps have been taken to create appropriate framework to overhaul the electoral process, beginning with the establishment of the first respondent as an independent electoral commission and extending to the enactment of appropriate legislation, including the IEBC Act and the Election Act, my Lord. The first respondent was thus established as an independent commission with the mandate to deliver elections which are simple, accurate, verifiable, secure, accountable, and transparent as enshrined in Article 86 of the Constitution. And this is the obligation, my Lord, which once we prove prima facie, and we will be able to prove that there were massive irregularities and these elections did not satisfy any of the standards which are required, then it is their obligation to satisfy your Lordship that they carried out an election which fits with the provisions of the Constitution. That burden is not on us. The burden on us is to give a prima facie case that this fundamental article of the Constitution, which anchors a free and a fair election, have been satisfied. My Lord, as it were, the first respondent adopted a hybrid system which was partly electronic, partly manual. My Lord, in the promotion of the system to the public, the first respondent presented that the way they were going to carry out the registration of voters was through the BVR system. And my Lord, they sold it by stating that BVR ensures quick and precise voter identification, and it is the cornerstone of any credible election. The system provides the highest voting safety levels and prevents fraud. My Lord, I would like to refer your Lordships to page 186 of my petition. My Lord, this was a public announcement made by IEBC, and this is what it states, my Lord, that BVR stands for Biometric Voter Registration and is computer-based registration solution. It is direct data capture system of voters. Biometric voter registration involves the use of biometric technologies with the use of computers, fingerprint scanners, and digital cameras to capture the biodata of applicants, such as personal details of fingerprints and the face photo. The technology is used to verify the authenticity of the voter and to ensure more transparency and credibility in the elections. Now, then the next question they ask themselves, and of course that would be fair, that would have caused a lot of concern, and that was for the disabled. So they say, what if a person is lacking essential limbs? Can he still qualify for BVR? And then they answer, BVR is a technique that uses fingerprints to register voters. In the absence of essential limbs, the registration solution provides for exceptions where voters with disability are clearly tagged and the face will be used for registration and identification. So it covered everybody. Then the next question they asked is, what makes BVR more efficient in producing a credible principal register? We'll come to the issue of principal register, and on that issue you will be told that they are now using some Juakali register called Green Book. And on the principal register, this was the answer. Biometric identifiers are unique to each individual and cannot be shared, and they intrinsically represent the individual's identity. This is an important feature in registration of voters and presents an opportunity to create a credible register with the technology. Biometrics can be used for positive identification only when the voter present herself at the voting station to ensure no absentee voting is carried out on the polling day. My Lord, we have a lot of Form 34s which are not signed by agents. We have Form 34s which show that more people voted than registered, my Lord. It is because if it was BVR, the only people who could have been admitted to those polling stations would have been registered voters. But once BVR collapsed, the system was open for manipulation by everybody and anybody. Now, my Lord, they then gave the advantages of BVR at Section 187, and that is unique. The biometric solutions have been developed around unique characteristics of individuals. The probability of two people sharing the same biometric data is virtually zero. Two cannot be shared because a biometric property is an intrinsic property of an individual. It is extremely difficult to duplicate or share. You cannot give a copy of your face or your hand to someone. Unlike old registration, where national IDs are used to uniquely identify the voter, and they themselves say was easy to forge and duplicate. Then they go on to say, cannot be copied. Biometric characteristics are nearly impossible to forge or spoof, especially with new technologies ensuring that the biometric being identified is from a live person, cannot be lost. A biometric property of an individual cannot be lost only in case of serious accident, unlike the manual registration, where a voter can lose the voter's card or national ID and the card used by imposters to vote. And accuracy. The accuracy of the data captured where a voter details are captured directly into the system with verification and confirmation by voters before saving information. The solution captures unique identification features of fingerprints and the face, which enhance production of reliable and credible principal register. Speed. The solution provides a direct data capture of details and require no more processing of information, which make it faster in consolidation of voters' register, unlike older technology that required verification and data processing. But my Lord, that was not their high point of sale to the public. Their high point of sale to the public is when they tell the public that even other countries are now relying on BVR. And this is what they say. Are there other countries besides Kenya who have conducted BVR? Yes. In Africa, there are Ghana, Nigeria, Gambia, DRC, Zambia, Sierra Leone, Namibia, Mozambique. And then what Kenyans fear most is normally radiation, and even for that they had an answer. How secure is BVR? BVR ensures quick and precise voter identification, and it is the cornerstone of any credible election. The system provides the highest voting safety levels and preventing election fraud. So that, my Lord, we as Kenyans were all the time aware that the only registration system we had was BVR registration system. Now, my Lord, and it is a matter of public knowledge, as every Kenyan is aware, the procurement of BVR became a major problem and challenge for the first respondent. And the procurement process was terminated among declaration of self-interest and discord among unnamed members of the commission. My Lord, if you look at page 175 of the petition, your Lordship will note that the commission announced that it was cancelling any further progress towards acquisition of BVR equipment. My Lord, there was a press release to the public. My Lord, page 175. My Lord, what they said, first, as usual, when things are bad, the best place for an institution to fall back on is a constitutional provision. So the articles begins with, Article 88 of the Constitution mandates the Independent Electoral and Boundaries Commission to compile and maintain voters' roll. The data must be captured and managed efficiently in a manner that secures the integrity of election, assures data security, and engenders public confidence. The Commission wishes to make it known to Kenyans that we have terminated the process of acquiring the biometric voter registration BVR kits. All the tenderers have been so notified. This tender has attracted considerable public attention. We wish to assure the public that all key stages in procurement process were guided by Commission's core values of respect for the rule of law, commitment to transparency, and accountability. Then why was it terminated? In terminating this process, Commission acknowledges that this will be a setback to the expectation of our commitment to automate the voter registration process. My Lord, they proceeded to terminate, and the rest is history. But having terminated, my Lord, they now shed their independent cloak and went to the government after the public had rejected their attempt to use optical mark reader, which is otherwise known as manual registration. The public rejected that. So they went to the government and requested the government to help them to acquire the biometric voter registration. My Lord, incidentally, the Gazette notice in respect of termination of that contract is found in the third respondent's affidavit at page 338. Now, my Lord, they now go to the government, and the government agrees. And they come back to the public with another advertisement now on 6th August of 2012. And this is what they say. The Commission issued a statement on 23rd July 2012 in which it informed Kenyans that due to inhibiting time constraints and procurement challenges, it resorted to optical mark reader for registration of voters. This elicited widespread disapproval by Kenyans, including all levels of political leadership, etc. Then they say these consultations culminated in today's meeting with two principals and attended by Vice President, several cabinet ministers, the Attorney General, the Chairman of CIOC, Mohammed Abdul Kadir, and high-level civil servants. In the meeting, the Commission emphasized, this is very important, my Lord, In the meeting, the Commission emphasized that its preferred option for registration has always been biometric voter registration. However, the acquisition of BABR kits was frustrated by cumbersome procurement laws and procedures, political and vendor rivalry. How that came to an independent commission, I don't just understand, my lord. In addition, the Election Act imposed strict timelines for the closure of the registration process, that is 90 days before the election date. After lengthy deliberation, the Commission requested that BVR be procured through a government-to-government arrangement. We are glad to inform Kenyans that the government has accepted the Commission's request and has committed to procure and deliver the kits on time for the exercise. So, my lord, even that was not, as is common with everything the Commission involved in, not beset with controversy. And at page 179, your lordships will see a clarification on what was a controversy on clearing the agreement between the IEBC and the amicus curiae. But be that as it may, my lord, the equipment was procured. There were articles showing that, as is usual in Kenya, the price turned out to be higher than was expected, but it was brought in and the exercise was successfully carried out, my lord. But, my lord, this was just to establish the biometric voter register. Concurrent with the biometric voter register, there was a necessity of procuring electronic voter identification devices, so that once the register is established, there would be then devices at every polling station to identify the voters who had been registered in the biometric register. And my lord, the advertisement for that was done in June 2012, and your lordship will find it at page 317 of our record. The advertisement was done sometime in June 2012. And my lord, the whole purpose the Independent Electoral and Boundaries Commission was going through this exercise is to ensure that the spectre of ghost voters and ghost votes is eliminated from our system. My lord, the specific objects of this tender is outlined in the tender itself, and it was to provide voter identification and authentication on polling day through the use of biometric fingerprint technology, to provide an effective means of reconciling the number of voters checked in with, and that is very, very important, my lord, that this technology was ensuring that the voter was identified. But two, it was also going to provide efficient and effective means of reconciling the number of voters checked in with the number of votes cast. So it was checking who came in, he must be registered, and once he votes, then it has to be reconciled with the number which came in. And my lord, it was also to reduce the human error by election officials and to ensure that the election areas were secured from unauthorized access. And at the end of the day, it was also going to provide, to generate end-of-day reports showing at a minimum the voter turnout, that is the number and percentages of registered voters clear to vote. So that, my lord, had this happened, we would not be before your lordship today. Because what we would now do is to know from the electronic records how many people came in, how many people voted, and how do we relate it to the result. And from 34, would only come to verify that. That is what was intended in the process which was organized by the Electoral Commission. Now, my Lord, it will be demonstrated that there were many instances where the voter turnout in polling stations exceeded the number of registered voters as per the register of February 18, 2013. My Lord, we will also show you that the explanation given by the Commission is absolutely unsatisfactory. Having deployed a failed EVID technology, it is then easy for the Commission to wish away the centrality of technology in these elections. My Lord, we will show you that the process started to go in a completely straight path, beginning with the tender, my Lord. The tender was eventually awarded to a company known as Face Technology by the tender committee, despite earlier findings by evaluation committee that it was non-responsive in many respects. And I would wish to refer your Lordship to page 352 of our petition. My Lord, page 352, there is minutes of the evaluation committee beginning at page 350, and 351 shows the number of persons who attended that meeting to evaluate the tenders in respect of EVID. My Lord, this was what they came up with. At page 352, Face Technology, the firm was represented by a Mr. Hunter and Mr. Charles Calliot. The firm system architect made presentation on the functionality of their device. The committee noted that the firm has not met the following specification. My Lord, they then outlined the specifications which have been met, and in fact they were the most fundamental specifications. In conclusion, the firm did not demonstrate prototype that met the POC requirements as stipulated in the tender document. However, the firm stated that they had received the communication late and were unable to prepare for presentation and provide the relevant prototype. They committed to provide a comprehensive demonstration there in resolution given another opportunity. So, my Lord, this was a firm which clearly failed in the tender evaluation. My Lord, let us have in the back of our mind that the first respondent is required by law to carry out its activities transparently on behalf of the public of Kenya. But, my Lord, that did not stop the mandarins at the first respondent's place. On 31st October, a meeting was called of the tender committee under the chairperson, Betty Sungura, and a couple of others. And, my Lord, in their evaluation, this is the recommendation they came up with at page 356. Recommendations. Even if the appearance of the device presented at the closing opening of the tender and that the proof of concept was different, the functionability of the second device was as per IEBC needs. Now they are overturning the tender evaluation. The device of POC had no specification, therefore cannot be pinned down. The addendum set at the tendering period shall be deemed as part of the tender document. The delivery timelines of supply of the devices need to be negotiated with the supplier who will be awarded the tender. There was, and then, my lord, they come themselves with caution that Face Technologies has problems. There was an issue about the negative publicity of Face Technologies in engagement with Uganda, loss of taxes, but also they had engaged with other countries like South Africa and even engaged with UNDP, therefore deemed reliable suppliers. Tender committee awarded the tender to Face Technologies. So, my lord, here is the first respondent awarding a tender to a person who its very own evaluation committee has said what this person supplies is not meeting the standards, my lord. My lord, the matter then went to the Tender Appeals Board. And, my lord, you will find the decision of the Tenders Appeals Board from page 369 to page 433 of our record. My lord, at Tender Appeals Board, having heard both the parties, the Tender Appeals Board had no doubt whatsoever that this was a corrupt transaction. And at page 428, 429, this is what they find. It is clear to the board that the following serious breaches of the Act, regulation, and tender documents have been committed by the procuring entity in the course of tender process. 1, failing to disqualify the successful bidder for failure to quote its tender price in compliance with clause 292 of the institution to tenderers that required a bidder to set out in its price inclusive of all custom duties, port clearance charges, VAT, and transport charges. Allowing the successful bidder to participate in the second demonstration of proof of concept, having failed in the first demonstration, and further allowing it to introduce a device that was different from the one that it had submitted with this tender. But, my lord, most seriously, adjusting the price of the successful bidder by a staggering sum of 4,294,139.13, allegedly to cover items in clause 292 of the tender document. This amount to change of tender price. So that, my lord, not only did they award to the wrong person, they even increased the amount. And, my lord, at the end of it, the tender board considered the Tender Appeals Board considered the issue and came to the following finding. Having said and having registered its dissatisfaction with the way this procurement had been handled, the board is nevertheless alive to the fact that the time left before the elections are held is short, and any decisions which it makes, which may interrupt the staging of elections, will not be in the interest of the country. It is for this reason that the prayers sought by the applicants in these cases, which are at the very least to carry out a revaluation, and at the extreme end to annul the proceeding in their entirety, would in our view not be in the interest of the nation. This view is supported by the fact that according to the minutes of Tender Committee, delivery of the devices will not start immediately, as negotiations still need to be held with the supplier. Confirmation still need to be made of the compatibility of the devices with BVR kits, among other things. It is clear to the board that the procuring entity is acting with impunity. And that is the finding of the Tender Procurement Appeals Board. Impunity, corruption, neglect of public duty. But the matter did not stop there, my lord. Even within the IEBC, its own director of technology said this system cannot work. And this, my lord, is found at page 434. In a letter from the director of ICT to the support services, this is what he said, my lord, and it is important to read all this. My lord, this, I'm going through the whole of this in order to show your lordship that there was a contrived interest in ensuring that technology does not apply to this election in spite of what was being sold to the public. And my Lord, this is what their director says. The above tender refers, the Directorate of ICT has held a consultative meeting with Face Technology, who won the above tender with a view of clarifying a number of technical issues, and wish to draw your attention to the following. 1. Device models proposed by Face Technology in the evaluated bid differs from the proof of concept model, which also differs from the model to be supplied. So that, my Lord, even what they intended to supply, IEBC had not seen. Face Technology proposed that they can deliver the equipment by 9 February 2013. Considering the strict timelines, this will give the Commission very limited time to carry out the necessary configurations, testing, and deployment to all the polling centers. 3. The bidder indicates that they will not be able to provide regional support for the devices to the Commission, but will maintain a central support desk in Nairobi. Our recent experience from BVR demonstrates clear value in decentralizing support to regions, especially for such time-critical electoral processes. 4. The original specification of EVID envisioned that the device would have 3G modules for data transmission. Face Technology can no longer supply this with EVID devices. This means that these devices will not have network connectivity. Your Lordships will remember that issue of network connectivity, which came on electronic reports. This was being raised at this stage on 6th December last year. This means that these devices will not have network connectivity to transmit provisional results and periodic voting progress reports from the polling stations. My Lord, that happened, and everybody is aware of it. It therefore means that the Commission will have to invest in parallel technology for result transmission system. Face Technology indicates that they will not load VR data onto the devices, as this is outside the scope of their TORs, although they have stated that they will provide a mechanism for data upload. It is not clear what type of infrastructure the Commission will be required to provide for this, and who will provide any additional devices required, and there will be enough time for the Commission to perform this task internally. We also add that there are other critical and competing priorities that make the realization of the EVID project risky. This activity includes the result system and the BVR project. We do not recommend that the simultaneous introduction of so many technologies so close to an election, since doing so leaves us with inadequate time to test, pilot, and stabilize these new solutions before full use. Recommendations. Based on the above challenges, the ICT Directorate recommends that the Commission considers terminating the EVID tender, since no contract has been signed yet, and then takes a progressive implementation approaching to pilot this solution, starting with the configuration of the 15,000 BVR kits for deployment to selected polling stations in each electoral area in March 2013 elections. This will require the BVR suppliers add this functionality in BVR kits. Look, it is very, very clear that, like the many projects in Kenya, this project to try and have an electronic system as part of our electoral process was beset with corruption, impunity, opaqueness, and with the knowledge by the very persons who are implementing it that it was bound to fail. Yet, they continued selling that to the public, my Lord. It is poignant to note that this memo, the author has sworn an affidavit before this court, and he has not denied this memo. In fact, he has adopted it as part of dialogue within the organization. My Lord, this clearly designed failure of a system had serious consequences to the electoral process. As indicated above, there were many instances where the number of valid votes cast in the presidential elections were well beyond the registered voters in those stations. This is evidenced by the data as failed by presiding officers in Form 34 and the returning officers in Form 36. And my Lord, we will show you the areas where that is done, my Lord. My Lord, what was also critical, that the failure of this system also led to complete mess in the registration process, as we will show your Lordship. In the result, we ended up with an election which nobody can confirm was transparent, was accountable, was accurate, and responded to the basic minimum standards, international standards, for a free and fair elections. Now, my Lord, what is the response of the respondents to this issue? First and foremost, my Lord, on the day of the elections, the respondent went on confirming to the public that these technologies were still working. And I would like to refer you, your Lordships, to page 216 of my record, my Lord. My Lord, page 216 was a press statement made on the 4th of March 2013 when the elections were carried out. And this is what the chairman told the public. First, my Lord, started with opening and closing of polling stations. We are not concerned with that, and the voting stations. And then identification documents, told the public that you will require your original national ID or valid passport, whichever you use to register. But please note that police abstracts and photocopies are not acceptable documents. So, my Lord, identification was very critical. But, my Lord, what is important for the purposes of what we are doing before your Lordship is identification procedure. The chairman assured the public that to confirm that you are a genuine registered voter, the following will be required undertaken. One is personal identification documents, that is national ID or passport. Two, reading of your fingerprints using electronic voter identification device. Everything. That was what he said would be applying on that day. And three, it is only after your fingerprints has been read that physical check would be carried out in the principal register of voters, my Lord. Then, my Lord, he went on to proceed at page 217, saying every voter will be issued with 6 ballot papers and for the following positions. And then, finally, my Lord, the most important other part is the results will be transmitted using mobile phone-based software and received for elected position by returning officer, for president by IEBC chairperson, and etc. In order to promote transparency and public participation in election, the IEBC will provide giant screens at the constituency and county tallying centers for the public to follow the inflow of results for various elected positions. So that, my Lord, to the public, the only means of voter identification, voter registration, and result was through electronic means, and that was confirmed as late as the day of elections, my Lord. Now, my Lord, what are we being told by the respondents about this? I would like to refer your Lordship to an affidavit sworn by the chairman of the Electoral Commission. And this is what he says about electronic systems, my Lord. And that is found at paragraph 10 of his affidavit. This is how it contemptuously and flippantly dismisses all this presentation to the public. In further response to paragraph 6 and 7, I wish to state that the design of the electoral system and the process of voting, counting, transmission, tallying, and announcement of election results as contemplated under the Constitution, the Election Act, and attendant regulation is primarily manual system of voting, which was configured with various safeguards to preserve the integrity of the process. The use of various electronic devices and IT was an additional instrument to make the electoral process more efficient and enhance transparency, but not a substitution of legally stipulated manual electoral process. From the Electoral Commission, what type of elections do we have? Are we on BVI? Are we on EVID? Are we on electronic transmission of results as he had presented? Or he can now contemptuously, about 36 billion shillings down the line, tell Kenyans these were all useless products. They were merely intended to be a supplement, my Lord. Lord, that is an issue you'll have to put in the back of your mind as you look at the various and numerous irregularities which have been committed by this commission. My Lord, his own IT expert, Mr. Ngondi, also confirmed that. My Lord, it is in his affidavit. I hope I have it handy. My Lord, he says this at paragraph 9. My Lord, he says that each of these technologies was intended to supplement specific processes and activities provided for in law and in overall act as a check and control on a practice that dodged the previous election. And then, at paragraph 10, the use of technology was never intended by the past respondents, or indeed the people of Kenya, to be the sole means of registering voters, identifying them or voting on voting day, and transmitting and tallying the results. That I verily believe that the proper place for technology, when one looks at the totality of the constitutional and legal framework and the process and procedures of the electoral process, was a check and control mechanism to be used alongside a slate of other checks and control that would ensure that the Commission fulfilled its mandate under Article 81 of the Constitution to deliver free and fair elections. Are they saying that the presentation they had made to the public all along, telling them that we are acquiring all this expensive technology in order to deliver a transparent election, was a lie and a fraud upon the public? It seems that is the case. My Lord, you will come to know why. My Lord, it starts with the registration process. My Lord, Section 4 of the Election Act states as follows. It says that voter register, there shall be a register to be known as the principal register of voters, which shall comprise of a poll register in respect of every polling station, a ward register in respect of every ward, a constituency register in respect of every constituency, a county register in respect of every county, and a register of voters residing out of Kenya. The Commission shall compile and maintain the principal register of voters referred to in subsection 1. So that, my Lord, what the law anticipates is that there is one register called the principal register. And from that principal register, you can extract all other registers for elections at different levels. That is what the law anticipates. My Lord, as it were, the voter registration process commenced on 17th November 2012 to the 18th December, my Lord. And your Lordship will remember that many Kenyans did not have the opportunity to register as voters. In fact, in many places, there was very low threshold of registration, but it was a limited registration for a limited period. And at the end of that period, the IEBC announced that it had registered 14,337,339 voters. And my Lord, you will find that from page 485 to 496 of the petition. My Lord, that was followed, page 485 to 496, my Lord. My Lord, that was followed by the register having been compiled. It was open for public inspection between 14th January 2012 and 27th January 2013. And my Lord, that is found at paragraph 31, or can I have a second respondent's affidavit? Lord, you will find at paragraph 31 of the affidavit by the second respondent, the chairman of Electoral Commission, that in compliance with election regulations, with the Elections Registration of Voters Regulation 2012, the Commission opened up the provisional register to the public for inspection and verification between 14th January 2013 and 27th January 2013. My Lord, then on 18th February 2013, following the inspection of the register, the respondent by Gazette notice confirmed that the register had been completed. My Lord, that is the most important part. Had been completed. And my Lord, that is found at page 506 of the petition of the petitioner. My Lord, this is what the respondent says at that page. He says, my Lord, that in exercise of the powers conferred by Section 21 ABC and the 9th of the 6th set of the Constitution, Kenya Section that of 6.3 AB and 4 Section 4.4A and AB of the Independent Electoral and Boundaries Commission Act 2011, Section 1091A of the Elections Act and Regulations 1214A and C of the Elections Registration of Voters Regulation 2012, the Independent Electoral and Boundary Commission gives notice that the compilation of the principal register of voters for the purposes of 4th March 2013 general election has been completed. Those are very important. Compilation of the register of 4th March 2013 has been completed. The certified register of voters may be accessed on the Independent Electoral and Boundaries Commission's website or at the office of the returning officer of different electoral commissions. So that, my Lord, as far as the law is concerned, the compilation of registers were completed on 18th February 2013, and the public was so informed in accordance with the law. My Lord, Section 6 of the Election Act states as follows, my lords. My lord, it states that the Commission shall cause the principal register of voters to be opened for inspection by members of the public at all times for the purpose of rectifying the particulars therein, except for such period of time as the Commission may consider appropriate. The Commission shall within 60 days from the date of the notice of general elections open the principal register of voters for inspection for a period of at least 14 days or such period as the Commission may consider necessary. And it ends up, the Commission shall, upon expiry of the period for inspection specified under subsection 1, compile the amendments to the register of voters, and as soon as practicable thereafter, being not less than at least 14 days before an election, publish a notice in the Gazette to the effect that such completion has been completed, and cause to be transmitted to every registration officer a copy of part of the principal register of voters relating to the constituency for which the registration officer is responsible to be kept in custody. So that, my lord, first, we had the first publication of the principal register, which was made in January, and members of between the 14th and 27th January, members of the public were required to inspect and rectify the register. And then, my lord, having had the rectification and corrected the register, there was another 14 days before the notice of 18th February was made, and that was to publish in the Gazette that the compilation had been completed. After that, my lord, the register goes to the constituencies, and the principal register now remains at the Commission headquarters. There was therefore no margin in law after the 18th of February 2013 to create any other register. Now, my lord, the following evidentiary materials now address themselves to the issues I have been going through, my lord. My lord, first and foremost, the affidavit of the second respondent filed on behalf of himself and the Commission annexes Exhibit AH2. And my lord, in that exhibit, what he is saying is that the total number of registered voters as per the Independent Electoral Commission was, it is found, my lord, at page 34 of that affidavit, is 14,352,533. My lord, I would then wish to refer you to his affidavit at page 18, paragraph 18. And my lord, this is what he says. In respect to paragraph 15 and 16 of the petition of affidavit, I wish to state that the tally of the registered voters had remained 14,352,545. My lord, you will see that there is a variation by a couple of numbers. It is not as is contained in his exhibited register, which is the number of 14,352,533, and in addition, 12 voters from Soy constituency in Washington Gishu, my lord. So now 12 voters have been added. And my lord, now new voters are being added. And a further 31,318 voters whose biometric information was not captured during the voter registration exercise. So, my lord, we have a figure of 14,352,533. There is an addition of another 12, and then there's an addition of another 31,318. Now, my Lord, your Lordship will note that in respect of the number of the so-called persons without biometrics, Isaac Isan says it was 31,318. When you go to the affidavit of the third respondent, my Lord, I will get the exact page and give it to you. The affidavit of the third respondent, the affidavit of Winfred Wacheke Guchu, annexed to the replying affidavit of third respondent at page 435 to 436. This is what she says. Sorry, my Lord. Just getting the right one. My Lord, she says that actually the number of these people without biometrics was 36,236. Again, a different number. My Lord, you will find that from page 435 to 436. Now, my Lord, first and foremost, up to now, I have read out to you all the public announcement made by the second respondent, my Lord. And indeed, for me, I confess, I don't know of any other Kenyan who has other information. The issue of some special register of persons without biometrics has been disclosed to me through this case. I never had before this that there was some group of registered persons called special persons without biometrics. And even if there were, their number varies, my Lord. And when you go and look at these numbers against the total number which was reflected in the final results in the presidential elections, you will note that it inflates the number of total registered voters by more than 36,000. So, my Lord, nobody knows how many are the registered voters in Kenya. My Lord, what is the second respondent answer to this? The second respondent answer is that political parties were informed, my Lord. But political parties are not voters. Their obligation is to inform the public. You cannot take a public right and wish it away by the allegation that I have informed political parties. And indeed, my Lord, my instruction is that such information never existed. So this was a secret register. And in the event, my Lord, was it possible within the context of an election act to have two separate registers, my Lord? The Election Act is clear, and registration is the very core of the voting process. In the event, my Lord, I always believed, but this case is teaching me otherwise, that IEBC was subject to the provisions of the Constitution. My Lord, fundamental among that is Article 10. And this is what it says, my Lord. My Lord, that our national values and principle of governance, which, my Lord, many Kenyans died. We are lucky that some of us did not suffer what happened to many Kenyans in trying to achieve this. And what the people of Kenya have decided is that their national values and principles of governance include good governance, integrity, transparency, and accountability. Why would the chairman of Electoral Commission be telling us that on voting day we would be identified through our thumbprints and the voting would be through a biometric register? Yet he has a special register which has what he says 31,318. The third respondent says 36,236, and nobody in Kenya knows except the few people who have that knowledge. In the event, my Lord, the second respondent, as a public officer, had accountability for the administrative acts and, more specifically, the obligation to give to the public in timely and accurate manner the information he had, particularly in respect of this public process called voting. My Lord, in respect of that, I would wish to refer your lordships and my lady to my Lord and my lady. I have always tried to use your honor. I had difficulty with it when I was at the ICC. I still have difficulty. And when I address you as my Lord and my lady, you will forgive me, because it has been drilled on us, on my part, for the last 34 years. So it will take time to get rid of the word. My Lord, when you go to Article... Thank you, my Lord. My Lord, worst of all, I was brought up in Kericho during the colonial days, and the discipline for the African was strict. So I am used to deferring to sir. Now, my Lord, Article 132 provides for value and principle of public service. And my Lord, second respondent cannot exempt himself. Him and his officers cannot exempt themselves from this obligation. And my Lord, this is what the article says. Lord, at D, it says that the values of and principles of public service include involvement of the people in the process of policy making. Yes, you can differ from what is provided, but this is a matter of public process. The public must be involved. You can't keep them out. And if you are keeping them out, you are not conducting these elections in conformity with the principles contained in the Constitution. And my Lord, if you go to E, it also requires public servants to be accountable for their administrative acts. And at F, it requires transparency and provision to the public of timely, accurate information. So that, my Lord, in proceeding to take us for a ride, that we were going to vote using a biometric register. My Lord, the second respondent was, and his officers were clearly breaching fundamental obligations which are imposed on them by the Constitution. Lord, I would wish to go to the IEBC Act itself. Their very Act, you have the IEBC Act. Well, you'll give me a minute while I get the IEBC Act. Lord, while my learned friend is trying to get it, I will just read to your Lordship what the provision says. My Lord, Section 27(1) of the IEBC Act provides that the Commission shall publish and publicize all important information within its mandate affecting the nation. And my Lord, information about a second register having, whether you call it 31,318 or 36,236, can it not be classified as important information within its mandate affecting the nation? My Lord, up to the time we came to this court, that information is not available to the public. My Lord, to the contrary, it is claimed that the information was contained in the second respondent's minutes, my Lord, which have only been disclosed before this court. And I would wish to refer you to the second respondent's affidavit at page 478 and 58, which will even bring much more confusion to this issue of registration, my Lord. My Lord, at page 447 of the affidavit of the chairman of the commission, Mr. Ahmed Isaac, but my Lord, as was consistent with all the proceeding hearing, it annexes the affidavit of, I'll tell you which one it is. My Lord, it annexes the affidavit of this is the other lady. No, not Kesat. This is the other lady. The affidavit of Dismas, my Lord. And this is what is contained at page 47 to 58. My Lord, it is a short note entitled Report of Candidates Meeting between Political Parties Representative and Commission at Bomas of Kenya on number 26 February 2013 and 5th March 2013 on election procedures and result transmission. So that, my Lord, is not very clear what it is all about. But it mentions 2 days. And in this, they say at page 48, following deliberations, party representatives were that, whatever that means, 31,000 voters could not be found in biometric voters register, and as a result, Commission compiled a list according to the county of origin. Could not be found on biometric register. My Lord, this is 26th or 5th March, many days after publication of the last voters register. And that there are other 2 lists. There are other 2 lists of special register, not 1 but 2. Your Lordship will note that now we have moved from that figure, 31,318 and 36,236, to now 31,000. And now we are talking about 2 registers. And we are talking about they could not be found in biometric voters registers. And it says the parties were informed that agents of the affected areas were to be given information on those who were to vote without use of the biometric. Not a register. Agents will be given information. My Lord, is this a process conceived by any law? Why did we pass the Election Act if it is at the discretion of the first respondent to conceive whatever registers they would wish to have? Is this law on registration binding on Kenyans, or it is not? My Lord, that's the issue you will have to ask yourself. And we're not talking about small figure. We are talking of a figure between 31,000 and 36,236. God knows who they are, where they are. And as 26, even if one were to agree that political parties were being informed, they were merely being informed that agents of affected areas would be given information. The voting is on the 4th, and that is the casual nature by which this matter is dealt with. As we are talking today, my Lord, I am not aware of any forum in which this so-called special register has been published for the public to inspect as required by Section 26. My Lord, the affidavit of Immaculate Concise annexed to the affidavit of the second respondent is even much more interesting, much more than what we have said, my Lord. Let me get it. My Lord, it is at page 184. It is volume 2 of the document they filed in court. The affidavit begins from page 184. And my Lord, I will, instead of going to her averments, I'll go to her annexes. And her annexes, my Lord, first begin with a meeting of 18th February found at page 201. Your Lordship and my lady will remember that that is the date when they said our registers have now been finalized. And my Lord, at page 202, this is what she says. Plenary directed that gazette notice be issued in compliance with the law. The certified register is to be uploaded onto the Commission website and the public notified of its existence. My Lord, this is what it says. Members considered the report on the preparation of the register as at 18 February, which highlighted the following statistics. 1. Registered voters with biometrics, 14,352,545. Registered voters without biometrics, 31,318. 31,000. Sorry, Madam. Again, confusion. There was a time when this country used to deal with billions, and every time I mentioned money, I would say so much billions.
Repeat that figure, please. Mr. Oraro, could you repeat that figure, please?
My Lord, it is 31,318. Then, my Lord, there was another number called confirmed duplicates, 13,237. My Lord, your Lordships can remember, it is not on record, but we can comment off record, that there was that figure of 20,000 which was being bandied around by the chairman of the Electoral Commission as the duplicates. Then they have another number called number of exceptions, 21,790.
Number of?
Number of exceptions. So it is 21,790. My Lord, this is on the day they are informing the public we have completed the register. Now, my lord, their meeting the following day, which is 19th February, is even much, much more interesting. And this is what they say. Page 205. Members reviewed the certified register. My lord, they have certified it, they now go and review it again, and took note of the explanation of variance identified. It observed that a team of officers from voter registration, ICT, and internal audit be constituted to report on the nature of variance identified. Your Lordships can now, and my lady, can now understand why I am saying that as we are talking today in Kenya, we don't have a principal register, and we do not know how many are the registered number of persons. And they go on to say, appreciating the level of accuracy obtained, emphasize the need to ensure that all those who enroll should not be denied the right to vote merely because of the Commission failed to capture correctly their enrollment as evidenced by their declarations. Now, where they got this declaration, God knows. The corrections are therefore to continue until all missing records are identified and appropriately corrected. Voters who will have been identified before voting day will be in special register, as it would no longer be possible for them to be included in biometric register. So that, my lord, they give a principal register, publish to the public, then they continue with the registration. How many, we don't know, and my lord, this is an offense in law. They were committing an election offense. Then, my lord, they come, now 23rd February. My lord, there is a meeting chaired by the second respondent and with all commissioners. And my lord, at page 207, the issue of voters register and each polling station is addressed, and they say, member considered the voters register at each polling station and directed the Secretarial to ensure that two Directorate of Voter Registration and Election Operation and ICT Directorate confirm if all the submissions from the constituencies on various amendments to the register, that is correction of names, wrong placements, and non-inclusion, have been incorporated to the register. So, my lord, what register was certified on 19th? If on 23rd February, they are now unilaterally amending their registers. They then go to say, all changes that are necessary but came after the register was certified should be in the special register, since it will no longer be practicable to make changes at the poll book system. Observing that there is unreasonably high difference between the provisional register and the register containing voters biometric, it was resolved that Directorate of Voters Registration carry out an immediate reconciliation. So that, my lord, public told there is a register, advertisement made, as at 23rd, which is over 5 days thereafter, they are still registering new persons and now creating another register called special register, and which is out of the principal register. Yet, the principal register is the only register known in law. Then they go on, my lord, at page 208 to say, in regard to 37.1 above, a special register is to be generated and will be used to allow voters to vote. Now, they're doing it secretly. Nobody knows who are these. Nobody approves. It is never advertised to the public. And they say, we are creating a special register and we will allow those people to vote. And they say, the confirmed duplicates will not be allowed to vote, and legal administrative sanction will be imposed if any attempted to vote. The special register will be as per a format.
Mr. Oraro, what are you reading from? I know it is a document, but is it the minutes?
The minutes of their meeting, madam.
The minutes of their meeting?
Yes.
Okay.
And the meeting chaired by the chairman, and all the commissions.
Okay.
So it is really the governing body of the commission now committing this clear illegality, knowing.
Yeah, I just wanted to get that clarification about the source of that information.
Thank you, my lord.
So that will do.
And my lord, it is on an affidavit sworn by them. It has been produced by them, not us. Then, my lord, they go, special register will be as the format presented by ICT as to contain details of the constituency, ward, polling station, name of voter, ID, elector's card, gender, and date of birth. Now, they say, so they create a complete separate register from the principal register. And they confirm these people will be allowed to vote. It is known they voted. How many voted is an issue. We might not be able to identify all of them. Regarding the issue of poll books, it was agreed that the FACE technology be requested to comply with the contract and that IEBC to provide the necessary support to them to ensure the project succeeds. So, my lord, this FACE technology, we have shown you the effect of the corruption and manipulation involved in this contract. And now, we have 6 days to vote, and the whole commission is meeting, saying, let's have FACE technology. Let them comply with the contract, and let's give them necessary support. Yet they knew from the start that FACE technology will never perform. And my lord, this helps the incident of special register. FACE technology was supposed to introduce biometrics identification, EVID. Without biometric identification, you can now use your special register, and you can admit more people if you wish. And my lord, in particular, it was resolved that FACE technology be requested to expedite the delivery of remaining 5,000 handheld devices to ensure that the devices are available for polling. The Secretariat was tasked to inform FACE Technologies on the offer from IFS regarding arranging of airlifting of devices from Hong Kong or China. Lord, they are now participating in performing the contract for their wayward procurement incident. So that, my lord, it is very, very clear that in respect of the register of voters, the law has been violated in every respect. So that, my lord, at the end of the day, what you ask yourself is, how many people voted at this election? Was it the 14,352,545 which they have presented were the total number of registered voters? Is it 14,352,545 and 26,236? And how about those 12,000 specials and those who are supposed to be taken out of the register? What was the effect of that on the register, my lord? My lord, we are talking about these large numbers, among whom it is impossible to ascertain how many people voted without very, very intensive inquiry, looking at the registers, the special registers, against the number who are reported. Yet, the margin between these two candidates is 8,000. 31,318 voters, 36,636, 12,000 taken out against 8,000. Lord, I have put in a list of authorities, and in my list of authorities is a case from India. It is called the case of Narendra Madifalapa Kenny and Manikarao Patel. My Lord, when I talk of 8,000, I'm talking about the threshold requirement under the Constitution. That is the amount of votes by which the third respondent has gone above the threshold. And here is a clear illegality establishing that over 36,236, according to the third respondent, or 31,318, according to the second respondent, were included among the voters by creation of what they call a special register. My Lord, whatever was created beyond the 25th of March, when they said, let us put a desk, and anybody who comes up with a form and says that he was supposed to be in the register and he was not, let him be included. We don't know what number is included in those registers, my Lord. My Lord, I have put in this authority, and it is concerned with the issue of registration. I don't know what is your Lordship's convenience, whether it would be worthwhile for your Lordship to be given the list which had been filed, so that as I go on through analyzing this, it is easier for both of us. Or
as long as you give us the percentages, the pages.
Yes, ma'am.
In your list of authorities, because we don't have them here.
My Lord, it will take me only 5 minutes to go to the registry and bring it to you, if that would be
just
convenient.
a minute. Maybe.
Okay, thank you. Sorry, that is convenient. Can you give me this passage?
Mr. Oraro, you can continue. We actually have a summary and the real thing.
Thank you.
Yep.
My Lord, first and foremost, before I go to the authority, what is poignant on this is the other issue. Where were these special registers used? Nobody knows. Where were they used? Which counties? Which constituencies? My Lord, what I have heard from the response which had been given to my indication of polling stations where there were excessive voters, the answer consistently is the additional names were in the special register. But we do not have concise information of where these registers were used. My Lord, this was a case dealing with the registration, and you find it, my Lord, at page 1 of my list of authorities. And the passage I'm referring to is at page 2.
Mr. Senior Counsel.
Yes,
Mr. Oraro.
Yes.
You just mentioned that the answer which was given by IEBC, that they do not have a concise information or something like that?
No, what I'm saying, my Lord, that in respect of each and every polling station where there is excessive voting, except one, voting over and above the registered number of persons, the answer is that the additional numbers were contained in the special register. My Lord, I see at page 558 of our record, petition 4, my Lord, in petition 4, page 558, page 558, my Lord, there is a document dated, this is second March, my Lord, it is a document dated 2nd March 2013, that is well after the final register. And my Lord, it purports to create statistics of voters without biometrics per county. And my Lord, a very quick perusal of that document shows that these numbers are overwhelmingly in the Rift Valley province and Meru. My Lord, it will be interesting to look at them at my ladies and your lordship's own time. They create a story of their own. And my Lord, in the event it is not for the Electoral Commission as they wish to increase the number of voters. My Lord, our section 5, I'll come to the authority, but before I come to that, I think it is better to give a background, the legal background to the submission I'm going to make, and which is consistent with that authority. My Lord, Section 5 of the Election Act provide that registration of voters and revision of registers of voters under this Act shall be carried out at all times except in the case of a general election or an election under Article 138(5) of the Constitution between the date of the commencement of the 60-day period immediately before the election and the date of such election. My Lord, there is a proviso, and it doesn't make sense. And I will give the second respondent the benefit of doubt in respect of that proviso. There is a proviso stating, provided that this applies to the first general election under this Act. That is what the Act provides. I would give them the benefit of doubt that perhaps it was a typographical error which was not corrected, and it was intended that this would not apply to the first general elections, perhaps. And I am not a counsel who likes to be pedantic to say, since that's what the law says, that is what it must be. Be that as it may, my Lord, Section 6 required them not to make any amendment or addition to the principal register 14 days before the elections. So that it was not permissible to make any amendment, let alone come up with a special register. But if you take Section 5 in its terms, their position was even much more precarious. Now, my lord, this was a case concerning registration, and this was the finding of the court at page 2. Inclusion of names in the electoral roll of a constituency, my lord, is the last paragraph of that page. Inclusion of names in the electoral roll of a constituency after the last date for making nomination for an election in that constituency must be visited with fatality. Such belated arrivals are excluded by the talons of the law and must be ignored in the form. So that, my lord, in the context of what is before your lordship, my lord, this is fatal. What was done was completely an illegal, irregular, unconstitutional action. My lord, it goes on to say, there is a blanket ban in section 23.3, and ours is both section 5 and section 6, on any amendment, transposition, or deletion of any entry or the issuance of any direction for the inclusion of a name in the electoral roll of a constituency and the last date for making nomination for an election in that constituency. This prohibition is based on public policy and serves public purpose. That is why, my lord, before a register is concluded, the public must have an opportunity to investigate it. And after the final register is completed, the public must again be given that opportunity. Any violation of such a mandatory provision conceived to preempt scrambles to thrust into the rolls after the appointed time, fancied voters by anxious candidates or parties, spells invalidity, and if in flagrant violation of section 23.3, names have been included in the electoral roll, the bonus of such illegitimate vote shall not accrue, since the vice of voidance must attach to such names. Such void votes cannot help a candidate win the contest. My lord, you will go and count these votes, and you will find that the majority of them were in Rift Valley and Meru.
Sorry, you seem to be losing your voice.
I think it is on account of diminishing.
Would you repeat the last statement?
My lord,
you can also do with some water.
Mr. Oraro, you said something important. Could you please say it in a manner that
my lord,
can follow it?
I will repeat it very loudly, my lord. Sorry, I am very sorry. Sorry, my lord, I will raise my voice a bit. In fact, my problem is that I cannot whisper, except today, when my voice seems to be disappearing. My lord, this authority ends up by saying that names have been included in the record. The bonus of such illegitimate votes shall not accrue, since the vice of voidance must attach to such names. Such void votes cannot help a candidate win the contest. And here, my lord, we have inflated numbers. And my lord, if they can't be apportioned, you are faced with a situation that they affect the result. But my lord, since there was a convoluted manner of voting in Kenya where candidates were supported in specific areas, the majority of these votes in special register are in Rift Valley, Meru, and Kiambu. How many voted, we can't know. But every time we are faced with excessive voters in a polling station, the special voters register is the answer. My Lord, another violation which was created in the course of this gerrymandering with the register was the transfer of voters. My Lord, Section 7 of the Election Act states as follows. Where a voter wishes to transfer the voter's registration to an electoral area other than the one the voter is registered in, the voter shall notify the Commission in the prescribed manner of the intention to transfer the registration to the preferred electoral area. And my Lord, this is very important. Not less than 90 days preceding an election. And my Lord, to this there was no proviso. So the consequence of this is that for the purposes of the last general election, you did not have an option but to be confirmed at the polling station where you registered. No voter could be transferred to another polling station. Lord, I'll give you an example of what the second respondent did. Lord, in respect of that, I would wish I'm referring to the affidavit of Immaculate Kasait annexed to the affidavit of the second respondent. My Lord, at paragraph 31, page 191, this is what she says. I have been informed by the returning officer Tabo constituency, which information I verily believe to be true, that as relates to St. Andrew Primary School in Tabo, that there were 130 displaced voters who were returned to St. Andrew before the poll date. They didn't even transfer their voting registration. They were just transferred. This explains the variance between the voter register 399 and from 36, 529. Those voters were relocated from Kipkeino polling station to St. Andrews. This was occasioned by shared BVR kit within the constituency and operator errors, which displaced a lot of voters in the constituency to Kipkeino, including voters from St. Andrews Primary School. The registered voters in Kipkeino polling station went down from 878 to 439. My Lord, this is what we call gerrymandering. There is an admission that they were even allowing people to go and vote in polling stations other than where they had been registered. It is there an admission in writing. Lord, can an election be carried in such a casual and cavalier manner? Does the way we are still just dealing with the issue of registers? Does the way the first respondent conducted the issue of registration and allowing people to vote without being in the principal register comply with the provision of the Constitution and the law? My Lord, the consequence of this was that there were quite a large number of places where people voted more than they were registered. And my Lord, when Your Lordship gave your order. The order for scrutiny, my Lord. No wonder you saw the Electoral Commission, which was completely unable to get the marked registers, except if they are given 10 days, rushed within 1 day with what they call the Green Book. This is the Green Book they are talking about, a book which was created after 25th, solely, singularly, at the discretion of the second respondent. It is now being used to try and legitimize persons who are not in the principal register. And my Lord, that is illegality being performed under the noses of the Supreme Court.
25th of February.
25th of February. That's when they started creating this special register. And with permission that they should be created up to the voting day, so long as the forms for those will be brought. And without participation of the public or any of the stakeholders. So nobody knows and can verify what is in those registers. Now, this brings about what in law is called the shifting of the burden of proof. I would wish to refer you to the Nigerian case of John Olukayode Fayemi versus Olusegun Adebayo Oni, found at page 17 of my list of authorities. And I would humbly submit to your lordships that the principles which were espoused in this case should apply with equal force to our Constitution. And why it should apply is because the burden of carrying out a simple, transparent, efficient, and accountable and verifiable election is on the second respondent, on the first respondent. And my Lord, what has happened before this court clearly shows your lordship the way that burden has been abandoned by the first respondent. Because, my Lord, it is their constitutional duty to create an accurate, verifiable, secure, accountable, and transparent system. Under their own act, my Lord, they have a duty consistent with Article 35 of the Constitution to disclose to every citizen of Kenya the information they are holding. But what are we being told, my Lord? Consistently, the defense before your lordship has been, they never applied for it. They should have gone to High Court, my Lord. It is their duty, once a petitioner established a prima facie case, for them to show that they carried out an election which is consistent not only with the Constitution, but with applicable electoral laws and regulations. This is what was being described on the Obafemi case as the